Hello and welcome back to the video updates. It's Sade. Today's question is going to address the question of how disinheritance works. This particular video would apply if you're just trying to sort out the inheritance for your family, or it could also help asset locators that are in the business of helping people to locate funds that they might be entitled to following a foreclosure sale. And the question comes up in the context of who would then be the rightful claimant. Definitely pass the file on or the information on to the lawyer that's helping you with those files, and the lawyer should be able to investigate more and tell you who would be the rightful claimant. If you like this video and find it helpful, please remember to click like. It keeps me motivated and encouraged to keep making more and looking for the right kind of content for you guys. And if you like the channel overall, please subscribe. I'm sure you've heard about people being disinherited by their parents or relatives. And this question came up in the context of excess proceeds, but of course it can also apply whenever people are sorting out the estate of a deceased relative or ancestor. So a disinheritance in its pure form means that the person that died had no intention of leaving anything to a specific individual, a specific child, or specific niece or nephew, or specific relative. So in order for us to go into this question, we have to understand the background. Typically when people would disinherit a child, it's because that child was not taking care of them, or they felt like that child abandoned them or whatnot. And in the past, people would express that verbally, right? But they never put it down in writing. And sometimes they never even had a will at all. So whenever you don't have a will, the intestacy laws would kick in. The intestacy laws are the default laws by which a particular state will divide up that deceased person's assets when that person dies without a will. And there is a hierarchy of parties or people, relatives, that would stand to inherit if there is no will. And if somebody leaves it up to chance, which is really essentially what you're doing when you don't have a will, then those intestacy laws would apply. And even that child that you planned to disinherit would actually still be able to get something from the estate. So how did the legislators handle that or figure that out over the years? In all states now, they have requirements that you have to do certain things. In all the states, they have specific requirements that you'll have to follow inside your will to show that you really do want to disinherit a particular person. So if you think about it in general, you could probably disinherit somebody by inclusion or by exclusion. The law prefers a particular way to do it. And when you're doing it by exclusion, that means that you list all of the children that you have, and then you specify that all of your assets goes to one particular child. Then of course you've excluded the other ones. So you can essentially disinherit by exclusion in that way, or you could do it by inclusion. And the law in the state of Texas and many states, they started considering the fact that the wills could be contested if I did the disinheritance by exclusion, because it could have been a typo. Maybe I wanted to actually leave those assets to all my children and accidentally left out some names. So they prefer that people do it through inclusion, meaning through specificity. So what does that look like? That means that inside the will, you have to mention that I leave my car to my son, I leave my house to my first daughter, and then to my last born, I leave $1. Or you could say I leave $10, or you could say I leave $1,000. So they want you to specify that person's name and then add the details or information as far as how much of your assets you want that person to get. So that's really the proper way to disinherit, and you will see that language in some wills. It kind of stings a little bit when people read the will, but the reason why the law has it that way is because people were contesting all those wills that tried to leave things open or try to be more gentle, less direct, and did it by exclusion. So you do want to disinherit by inclusion. You mention specifically that child's name or that relative's name and say, to so-and-so I leave, $10. And then everybody knows that it's clear. And of course, there's always that clause also about contesting the will. If you contest and lose, then you lose everything that you were given in the first place. So that's just how the disinheritance will normally work. And the question that we got at the office was asking us to look into a file where there were excess proceeds left over and somebody wanted to prove that another party had been disinherited. So I explained that has to come in the form of a will. It cannot be just a written note. Typically, it cannot be a handwritten note. It cannot be an affidavit. Of course, wills can be handwritten. They're called holographic wills, and they can be proved up as the actual will, last will and testament of that person that died. So in that scenario, then yes, that handwritten will would apply, and that person that is being disinherited, if mentioned in the handwritten will, the court would allow that. But first, that will has to be admitted to probate. It doesn't just automatically happen because I produced a document that I said is my mother's will, and court that's in charge of the excess proceeds may not agree with me. They would want a court order from a probate court showing that that will is a valid will, written in the handwriting of the deceased person fully, and that it's been proved up. So those are the steps or pre-steps to getting to the point of being able to claim any excess proceeds. Then another similar scenario that we had is that an ex-wife actually wanted to claim excess proceeds from a deceased ex-husband. And obviously, that would not work. All states pretty much agree that if a spouse is mentioned inside a will while the couple was still married, and now the couple has been divorced, the will is still valid as far as all the provisions inside the will, but the will would be read as if that ex-spouse, the now divorced wife, actually died before the ex-husband. So let me repeat that. Pretty much in all states, it's agreed that if people were married and the will was written during the marriage and they're now divorced, the spouse that was supposed to inherit under that will no longer inherit. But the will will still be valid. However, the will will be read as if the spouse that was mentioned in the will actually died before the ex-husband. So in this case, the ex-wife's name inside the will would not matter. It will just be struck off, and the whole will be read as if she actually predeceased him. So that's what I explained, and that's actually the law here in Texas. I think it's the same in all the states. And so you don't get to inherit from somebody that you're no longer married to because they intended for you to inherit because you were married to them back then. If after the divorce, however, your ex-husband decides to then update his will and names you as an individual, not as a spouse, inside his will, and says that he would like to leave his whole estate to you, then you can definitely inherit that way. The other way you could inherit is if the will was never updated, but you both remarried. So let's say you divorced in 2010 and now you remarried in 2020, and he never updated his old will from 2005, then you could still inherit from him. So you could still inherit from him as long as the new marriage lasts. So that's the way that it works. You don't inherit from your ex-spouse unless he writes a whole new will or updates his will and specifies that he's no longer married to you, but he would like to leave all of his assets to you or some of his assets to you. And remember that with the disinheritance, you can't just prove it up by bringing neighbors or witnesses saying that that person intended to disinherit that child. It normally has to be inside a written will. and that will should already be admitted to probate. So of course, asset locators need to know this, because when you're working with people, they tell you different stories. They want to convince you that they're the rightful claimant to claim those excess proceeds. So I thought I'll do this quick video. It should be short and to the point so that you remember it. If you're going to take anything away, it's that ex-spouses typically don't inherit under a will that was written during the marriage and never updated after the divorce. And ex-spouses can only inherit from an ex-husband or wife if they actually remarried and they're still married now. And so yeah, they can use that old will. And then of course, the last thing you want to take away is that when somebody is disinherited, then you would not probably know that until a lawyer reviews the file and looks through the will and makes sure that it's either already admitted to probate or it could be admissible as a good, valid will. So this is my quick video for you for today. I hope your week is going great. If you like the channel, remember to follow us and subscribe and click on that bell so you get notifications of new videos. And if you like this particular video, please remember to give it a thumbs up. It keeps me motivated to make more, keeps me motivated to keep coming back and coming up with content that might be useful to you. So thanks as always for watching, and I hope you have a wonderful weekend, and I will talk to you next time.